Ladies and gentlemen, I'd like to welcome you to the American Society of International Law. We're very excited to have you join us for the very first of our Human Rights series this year in cooperation with American University's Academy on Human Rights. To give you, for those of you who are not familiar with ASIL, we are a 107-year-old nonprofit organization that focuses on education and information resources on international law. And that's any topic of international law, everything from family law, international business law, national security and international space law, environment, anything that you can think of that has an international legal element to it, we have members who are interested in. We are a membership organization, which also means that we are a non-advocacy and non-partisan organization. We pride ourselves on being an area where you can come and have a rational discussion and engage in conversation with people who don't necessarily agree with you. And it feels like there are fewer and fewer of those places around DC anymore. So we're happy to serve in that context. We are also focused on a public education mission, and that includes educating everyone from high school students and teachers all the way up to members of the current International Court of Justice. And so we work very carefully on those programs, including a judicial education and outreach program, a general public education program, and our continuing legal education program as well, as which this event is one of those. We have a long cooperative history with the American University of working on these types of programs. We're very pleased when they offer to bring together the speakers from their human rights series or sessions and do a series of human rights related topics at ASIL, and we enjoy hosting them. So without any further ado, I'm going to turn it over to our moderator to introduce herself and the panel, and I hope you all enjoy tonight's event.
Thank you very much. Well, I'm Laurence Burger-Larsen. I'm from France. I'm professor in law at the Sorbonne Law School, and I'm very, very delighted to be present here in this prestigious and lovely, very lovely American Society of International Law headquarters, to introduce our speakers and also to debate in a very few and quick words concerning the implementation of CEDAW towards sexual and reproductive health rights. I am surrounded by three amazing persons, all of three top experts, really, in the field of human rights and health rights. They are coming from different areas. The Academy, from Rebecca Cook, and who is professor in the Faculty of Law of Toronto and coordinator of the International Reproductive and Sexual Health Law Program. Her publications are numerous, and one of them, a very, very recent one, has been noteworthy. The title of the book, co-written with Simon Kozak, is Gender Stereotyping Transnational Legal Perspective, a very amazing book, Rebecca. As for Aram Chevet and Emily Moratin, they are coming from the world of NGOs. Aram Chevet serves as the Policy Council for Foreign Policy and Human Rights at the Center for Reproductive Rights, a global human rights advocacy organization dedicated to using litigation and advocacy to advance reproductive freedom in the United States and around the world. And Emily Martin is Vice President and General Counsel of the National Women's Law Center. She undertakes cross-cutting projects addressing women's health, economic society, security and education and employment opportunities. All of us have an impressive knowledge on the topic of our panel, thanks to their very strong specialization on the matter. And I'm sure in this context that the presentation, as well as the debate, will be very, very fruitful. We can say that from a normative point of view, we can argue that we are disposing today of all the relevant tools, especially at the international level, with the CEDAW, to face different and very numerous challenges on the matter of health care and reproductive rights. The CEDAW, you know, is a landmark international treaty that affirms principles of fundamental human rights and equality for women, And Awam will talk first, presenting us the CEDAW in itself, and above all, the important CEDAW Committee works. The speech of Rebecca will be very complementary, exposing a practical case, the well-known Elimination case. And we will finish around our roundtable by saying that if the majority of states has approved the CEDAW, ratifying it, some continue to be reluctant to accept it. And Emily Martin's speech will remind us this crucial point, talking about the efforts to ratify CEDAW here in the United States. So the debate will be, I'm sure, the debate will be strong. So let's start with our for the presentation, general presentation.
Wonderful. Thank you so much, Laurence, and thank you all for attending this and braving the heat to get here. So the topic that we're discussing today, the implementation of CEDAW, and particularly as it pertains to sexual and reproductive health and rights, couldn't be more, I think, both important and topical. And I'll present a little bit of an overview of CEDAW implementation as a whole, and then Rebecca will be speaking about one of the cases that actually our organization, Center for Reproductive Rights, was one of the litigators of in some greater depth. So just to get started, when we're speaking about reproductive rights, there isn't one definition out there that is the definitive one, but the most subscribed to definition is the consensus definition from the ICPD, which says that reproductive rights rest on the recognition of the basic right of all couples and individuals to decide freely and responsibly the number, spacing, and timing of their children, and to have the information and means to do so, and the right to attain the highest standard of sexual and reproductive health. Now, that's not part of CEDAW specifically, but it does come out of CEDAW and some of the other international human rights treaties. And what's, I think, important in that definition, especially as Americans looking at a treaty like this, is that it marries together, maybe bad turn of phrase, but together both a right and a means of achieving that right, and that those two are fundamentally inseparable. You have a right, but you also have the right to have the information and the means to do so. And that, is in many ways very different from our constitutional system, where we really have a right in the abstract, but there's very, very little protection for a way to achieve that right. So CEDAW protects reproductive rights both directly and also indirectly. We know also from the ICPD consensus that reproductive rights embrace certain human rights that are already recognized in national laws, international human rights documents, and other consensus documents. So there's some protection that's given directly for sexual and reproductive rights, and there's others that sort of come out of the penumbras or the shadows of the treaty. In terms of protection of sexual and reproductive health, CEDAW protects, among other things, there's a guarantee of no discrimination in healthcare, including access to family planning. It guarantees access to pregnancy services during the prenatal period, the so-called confinement, and postnatal services, including non-discrimination provisions for rural women and access to healthcare and family planning. There's equality between men and women in deciding freely and responsibly the number and spacing of children and having the same information, education, and means to do so, similar as in the consensus document. And the right to access educational information, including information about comprehensive family planning. There are other provisions, of course, about equality in marriage, non-discrimination generally, non-discrimination based on maternity, and adding that the protection of pregnant women, prohibitions on stereotyping, and then other things that are a little bit more far afield but also related, of course, freedom from sexual violence and freedom from traditional practices such as female genital mutilation. So those are a large bundle of rights, among others, that are protected by the CEDAW Convention. So let me talk briefly then how it's actually implemented those rights. And I'm going to talk about it in three different levels. First at the level of generality, second at the country level, and then third at the individual level. And it has protections at all three levels. At the highest level, at the general level, CEDAW, like other human rights bodies, promulgates general recommendations, which are the authoritative, although not formally binding, but authoritative interpretation of how the treaty is to be read. General Recommendation 24 speaks to the right to health, or the right to non-discrimination in the context of health, guaranteed by the CEDAW Convention and sets out 3 standards that governments have an obligation to respect rights, to protect rights, and to fulfill those rights. So respecting the rights means that the government needs to be hands-off. The government can't actively interfere in those rights. That's sort of the way that we view rights generally here in the United States. But the second and third ones, the protection and fulfillment, go beyond that. That there's an obligation to protect those rights. Not only that the government has to be hands-off, but that the government has to protect those rights from the acts of third parties, including private non-governmental actors, an issue that is central in the Elimination case, which Rebecca will be speaking about. Third, there's a duty to affirmatively fulfill the rights and to take appropriate measures to the maximum extent of available resources to ensure that women can realize the right to health care. So it's that the government needs to be hands-off, the government needs to protect the right from third parties, and the government needs to affirmatively do what it can within its available resources to bring that forward. So that's really important framework in general, put out in General Recommendation 24. There's also some substantive pieces in there. For example, there's a paragraph that speaks to that it's discrimination for certain kinds of health services, including reproductive health services, to be withheld from women, and talking also about things like religious refusal laws or conscientious objection laws, something that we're hearing a lot about here in the US. So that's sort of at the most general abstract level. Those general recommendations apply to sort of simultaneously every country, but no country in particular. It's the guide to understanding the treaty. With regard to specific countries, of course, there's a monitoring process where countries are individually reviewed a certain batch at a time, every certain amount of period, where the CEDAW Committee, a committee of experts, will look at the country's record on women's rights protected under CEDAW, including sexual and reproductive health, and sort of offer its guidance and recommendations for what these countries ought to do to become more compliant or better compliant with the treaty. And, you know, every country gets reviewed, or virtually every country gets reviewed. You know, these are fairly long documents, but just to give you kind of a taste of one, the recommendations, or rather the observations and recommendations are rather broad and very wide-ranging. So, for example, the concluding observations with respect to Mexico in 2006, the committee talked about its concern about high maternal mortality rates, including of indigenous women, access to healthcare services, including sexual and reproductive health care, concern that abortion remains one of the leading causes of maternal death, that there isn't access to safe abortion services, that there isn't access to a wide range of contraceptive measures, including emergency contraception, and that the government isn't doing enough to prevent teenage pregnancies. Phew, right? A lot. And with these prescriptions, they're also similarly very broad and wide-ranging, talking about urging the state party, in this case again Mexico, to expand the coverage of health services, including reproductive health care and family planning, to address sex education, to harmonize legislation pertaining to abortion at the state and federal levels, ensure effective access to safe abortion, ensure access to a wide range of contraceptive measures, including emergency contraception, sensitization campaigns, and so on. So on the one hand, you know, this is really helpful because it's extremely broad and extremely wide-ranging. It really looks at all sorts of issues all along the spectrum and identifies those. It doesn't sort of take a microscope and look at one particular issue in great depth. That's also, of course, the weakness of this kind of treaty implementation, is that, you know, this is not a particularly useful guide. If you say, well, you know, you should have more, you know, sex education should be more widely promoted. Okay, you know, what does that mean? What does it mean that women should be offered a wider range of contraceptive measures? I mean, it has some meaning, of course. I'm not trying to say that it's devoid of meaning, but it's not necessarily the most helpful guide for an individual country that's looking to better implement what's going on. So the third level of analysis that the CEDAW Committee does is through its individual complaints mechanism. And this is through an optional protocol. The CEDAW as a whole has, I believe, currently 187 state parties. The individual complaint mechanism has slightly more than half that number, about 104 parties, I believe. And this is a process whereby which individuals who believe that their rights under the treaties have been aggrieved can petition and try to seek redress from the CEDAW Committee as against the country in which they live. So I'll touch very, very briefly on the Elimination case, one of the cases that my organization litigated, but obviously Rebecca will be talking about this in depth. The case concerned a poor Afro-Brazilian woman who was denied adequate prenatal care despite showing signs of serious complications and sadly died. The redress that she was given in the decision of this case was a statement that governments have a human rights obligation to guarantee that all women in their countries, regardless of income or racial background, have access to timely, non-discriminatory, and appropriate maternal health services, and that governments also have an obligation to monitor private institutions, and that governments can be held responsible for the actions of private institutions, you know, sort of under a sort of respondeat superior kind of theory, that they have a duty to monitor and to regulate these private institutions. In terms of implementation, I won't get into a lot of detail because the negotiations are actually ongoing, literally even as we speak. But the country in this case is Brazil. And generally speaking, although there's a lot left to work out, implementation has been positive. The government has taken its obligations seriously. My colleague who was involved in the litigation informs me that this is actually the very first time Brazil was essentially named as a defendant in the international human rights system, not including here the regional system like the ICHR, Inter-American Commission on Human Rights, but for the UN system. You know, the issues involved maternal health, racial disparities, and the nature of the issue itself, access to prenatal care, the fact that Brazil has now a female president, all these things sort of combine to make it a priority for the government. And while, again, it's sort of a work in progress, it does seem like implementation there is a relative success story as far as these things go. Sadly, the case is not the same, and I'll end with this, with another case that the Center for Reproductive Rights brought through the CEDAW Committee, which was the LC case, L.C. being the initials of the person in question. The case facts, very briefly, are really quite sad. There was a 13-year-old girl who was repeatedly raped over a period of time by a neighbor. And she eventually became pregnant and was despondent and tried to commit suicide by jumping off a building. And she didn't die, fortunately, but she then became paralyzed from the neck down. And the doctors, the medical experts were saying you need to perform surgery immediately, you know, or else the paralysis is going to be permanent. And basically the medical system hemmed and hawed for 3 months. Later there was a stillbirth, and the surgery to fix this LC's spine came too late and was ineffective, and she remains basically paralyzed from the neck down. The decision that came out in 2011, so 2 years ago now, ruled that Peru should consider amending its law to allow women to obtain abortions in the cases of rape and sexual assault, to establish a mechanism to ensure availability of abortion services, and of these abortion services, and to guarantee access to abortion services when a woman's life or health is in danger, which was already nominally permitted under Peruvian law. Sorry, I didn't say Peru was in this case the respondent state, which was nominally legal. But there was no implementing legislation, there was no policy, no process, so every hospital sort of had to wing it and make up their own rules as they went along. It's somewhat similar to the situation in Ireland that people are familiar with the ABC case. The CEDAW Committee also ruled that Peru should pay compensation, including medical compensation, to LC. And, you know, again with this case, the negotiations are ongoing, so I don't want to sort of say anything, but it's been a fairly frustrating process. You know, that, you know, Peru has started conversations about compensation, or about both individual compensation to LC or general compensation in terms of changes systemically with, you know, none of this is binding, which, though true as a matter of law, is sort of not the most helpful place to start any kind of real fruitful discussion. You know, Peru's had apparently some guidelines on abortion that they could roll out, but haven't. They haven't really moved forward in terms of decriminalizing abortion in the case of rape. And even the kinds of symbolic or reparations, you know, monetary reparations to Elsie and her family for these medical bills have not been forthcoming. You know, there's some hope the government, we actually asked the government to meet with her directly, and they did, which to their credit, but, you know, again, the follow-up is sort of very much, we'll see what happens. So, you know, it's kind of a mixed bag, and I think we can definitely talk about this in the Q&A period. So, thank you.
Thank you very much. It was a very interesting speech, very clear speech, pointing out the positive element as well as the weakness of the system. It was a very objective speech. Thank you very much. Now let's start. Let's begin. Let's continue with Rebecca.
Okay. As Avram said, I'm going to talk specifically about the significance and the effectiveness of the Aline case. This was a maternal mortality case, an avoidable maternal death that was brought against Brazil and was decided 2 years ago. And my work recently has been to do a case comment on that case. The reason why I chose Aline as to do a case comment on it is because of its significance. It is the first international human rights decision on preventable maternal death. 30 years ago, we did not know. We had very good statistics on infant and child mortality, but we did not know about maternal mortality. And there was a very famous article that was written by Alan Rosenfield and Deborah Main in The Lancet that said, "Where is the M in MCH?" published in 1985. Where is the maternal and child health? Up until that point, maternal and child health programs had seen women instrumentally, had seen women as instruments to ensuring infant and child survival. So much so that we didn't even have the statistics. The article caused an absolute uproar, and as a result of that article, there has been a series of international meetings, first in Nairobi, then in Sri Lanka, and now there are several partnerships for maternal and newborn health, funded by the World Bank, the World Health Organization. But this program has not been, human rights has not been an integral part of this program. So one has to ask, what is the value added of human rights to programs on maternal and child health? We have the Millennium Development Goals, and by 2015, we are not going to achieve the Millennium Development Goal of having maternal mortality by half since 1990. This is outrageous. This is 2013, and we still do not have the wherewithal. We have the wherewithal, but we do not have the political will to move forward on reducing preventable maternal death. Now, these maternal deaths, they're not expensive. The World Bank has done a study a few years ago. It was about $3 per head to prevent maternal death. These are horrible deaths. These are women hemorrhaging in childbirth. If you've ever seen anybody hemorrhage, hemorrhaging is pretty shocking. But a woman trying to give birth, to give life, hemorrhaging in childbirth is pretty tragic. So the question for us as international lawyers is, why do we bring cases with regard to preventable maternal death? Well, I've answered this in many different ways in the article, but I think first and foremost is the fact that now countries that do not address their preventable maternal death can be held legally accountable. So preventable maternal death is now legally cognizable. Now, it's not as though maternal mortality was recognized as a problem when the Universal Declaration was written. There is a provision in the Universal Declaration on the importance of protecting maternity. There's a similar provision in the Brazilian Constitution. But as many of such documents, whether they're international or national constitutional documents, they were mere skeletons. And this decision, in terms of its significance, adds flesh to these bones. Preventable maternal mortality is now a matter of human rights. It is no longer a matter of fate, destiny, and divine will. And up until 30 years ago, it was thought that it was a matter of fate, destiny, and divine will. So it's hard in today's world to understand the importance of making this right legally cognizable. Because many even economic, social, and cultural rights are now legally cognizable. But this decision, thanks to the Center for Reproductive Rights and a Brazilian group called Avocadi, has made this legally cognizable. But the other thing that's terribly significant about this decision is the way it was framed. It is not just a matter of a violation of individual rights, but they were careful to frame the whole question as a systemic violation. And human rights are often criticized because they are seen as too individual. But this decision is historic because it looks at the health system's failures and does not necessarily scapegoat doctors. Yes, it was a malpractice case. Doctors should have recognized a woman coming to the clinic was nauseous. They should have suspected that she had a dead fetus and needed to have it extracted as soon as possible, but they didn't. But instead, the malpractice issue is taken care of at the domestic level. But what this decision is really, really brilliant at is the fact that they hold the system accountable and that the remedies that they order are to change the system, to train the doctors better, to ensure that the hospitals are equipped, to ensure that there's a proper referral system, and to ensure, as Avram said, that we have to ensure that when we contract out to private healthcare clinics, obligations of government, which this clearly was, we have to monitor those private healthcare clinics to ensure that they comply with standards. So the fact that they concretize the government obligations with regard to the health system to address preventable maternal death is another very, very significant aspect of this decision. The third significant aspect of this decision that I want to touch on, and this is pulling in other aspects of international law, in a brilliant article, only 3 pages, by a former colleague now at NYU on measuring the effectiveness of international law, is it legitimized and legalized the World Health Organization standards with regard to emergency obstetric care. This is incredibly important. But because these WHO standards, very important in terms of medical standards, to ensure that countries have developed emergency obstetric care to deal with these preventable causes, they had not been legitimized in international law. So in terms of the significance of the decision, it's legally cognizable, the fact that it concretized government obligations with regard to health systems obligations, and legitimized the WHO standards with regard to emergency obstetric care. And one could also say it legitimized the International Federation of Gynecology and Obstetrics, their standards with regard to treating postpartum hemorrhage, which this one taught up. So that's the significance, and I'm just sketching. There's many other aspects of this decision, and if you really want to know more, you can read the article. But let's step back and think about ourselves sitting here 5 years hence. How can we think about the effectiveness of this decision 5 years hence? Well, I argue in the article that, yes, we need to look at Brazil's compliance, particularly with regard to the compensation to a means family, which I understand is progressing, although they have not yet made a formal announcement. Yes, we need to look at Brazil's compliance with regard to how the health system has changed with regard to the delivery of emergency obstetric care. But we also need to look at the normative effects. So CEDAW has developed a very important general recommendation. Avram referred to the general recommendation referred to general obligations, but it has a specific general recommendation with regard to women's equal access to health care, or general recommendation 24. 24 very significantly says that neglecting health care that only women need, maternity care, for example, cervical cancer, abortion care, breast cancer, although breast cancer also happens in men, but in a very select minority of men. So this is the first decision that actually applied this general recommendation that said neglecting health care that only women need is a form of discrimination. It's opening the door to looking at the gaps in healthcare systems with regard to women's health as a form of discrimination. Now, the lawyers in the room understand how significant this is. The Center for Reproductive Rights, our clinic at the University of Toronto, hopefully the clinic now under Oscar Rivera's leadership at Georgetown, will lead the charge on equality in access to health care. For too long, societies have not understood that ignoring women's health is a matter of women's equality. So this decision from that regard is very significant. But 5 years hence, will the Brazilian judiciary adopt this kind of thinking? There's a big debate about the judicialization of health in this symposium edition on global health issues that just came out from the Journal of Law, Medicine, and Ethics of the American Society of Law, Medicine, and Ethics. I have a Brazilian colleague who critiques the judicialization of health in Brazil because it's seen just as a way of the middle class to get access to their meds. This is an opportunity for the Brazilian health judicial system to say the judicialization of health has to be about a matter of women, particularly poor women, marginalized by race, getting access to essential health care. So the judicialization of health in Brazil shows what the judiciary can be doing. Yes, it's not having a huge public health impact, but it could be having a dramatic public health impact. And you're probably all familiar with what's happened in Brazil with regard to HIV and access to HIV medicines. The judiciary has been very, very significant with regard to that. Very significant decisions. Remains to be seen, if we had a meeting 5 years hence, we could measure the effectiveness of how CEDAW has impacted, the elite decision has impacted on the judicialization of health in Brazil. So that's ensuring women's equal access to health care. The other significant aspect that we would have to look at if we met 5 years hence is what this decision did with regard to intersectional discrimination. Sex, race, and poverty. This was a poor Afro-Brazilian woman who should not have died. You could say she didn't die, she died because at the clinical level there was a racial bias. They did not treat her initially. Why? It suggests it's racial bias, but we don't need to go there because there is a clear holding in this decision that this was a matter of intersectional discrimination again and first. So 5 years hence, we can come back and see what's happened in terms of whether this decision has had a normative effect that it hopefully will have. interesting thing about this decision is in international global health terms, the idea of health equity is really a relatively new idea. And you have some really brilliant articles. I could probably put them all on one page. The top of my list when I teach this in medical schools is Paula Braden, a brilliant epidemiologist who thinks about health equity, thinks very deeply about what health equity means and how we can measure it. With maternal mortality, we could come back 5 years hence and see whether women have, that maternal mortality has actually declined. Now, fortunately, as Avram suggested, in Brazil, we're moving at an open door. This is a country that has democratized their healthcare system. They have a whole monitoring system around maternal mortality, state by state. They have maternal mortality committees. Yes, some are functioning better than others, but at least they have a system. At least they're trying. So in terms of health equity, we can crunch the numbers 5 years from now to see whether the gap between Afro-Brazilians who die at 7 times the rate that that women of reproductive age die in childbirth. I mean, Brazil's not the only country. In the US, Afro-Americans die at 4 times the rate. It's an order of magnitude, but it's pretty embarrassing that a country as rich as the US has the same problem. I don't need to point to the US, and in Canada we have the same problem with our indigenous population. So closing the gap between Afro-Brazilians and those women at large would be another way to measure the effectiveness of this decision. Let me end where I began. This decision is of monumental importance. Because women's rights have been drowned out by terrorism, Syria, climate change, it will not get the recognition it is due. The Center for Reproductive Rights will not get the recognition it is due for bringing this case. How they framed the case, how they negotiated the case, but this is a monumental decision, particularly if you understand that 30 years ago we did not even count maternity.
Thank you very much. Thank you so much, Rebecca, for this both humanistic and technical speech. Very, very interesting and about a very sad decision, but not sad case, but very bold and promising decision, of course. So let's continue with a very, very conflicting point about the US ratification of the CEDAW.
So the National Law Center where I work is part of the CEDAW Task Force, which is a group of about 190 organizations working on US ratification of CEDAW. As has been mentioned, 187 UN member countries have ratified CEDAW. That means there are only 7 that haven't. The US, Iran, Sudan, South Sudan, Somalia, and 2 small Pacific islands. So it's a very small club that we are a part of, and not the sort of club that we usually take pride in being a member of. CEDAW was signed by President Carter in 1980, but it has never been brought to the Senate floor for a vote. One reason for that is no doubt because it takes 67 votes in the Senate to ratify a treaty, assuming all senators are present voting, which has only become a harder hurdle over the years to meet. So the task force is seeking a Senate vote on CEDAW for lots of reasons. It's long past due. One reason is because we think that even if such a vote failed, that the fact of the vote itself is an important organizing moment and important for senators in the United States to demonstrate and to be on the record about where they stand on CEDAW and on women's equality. The Obama administration has expressed strong support for CEDAW. So, for example, there were hearings in 2011 and 2012 where Melanne Verveer, the global ambassador for women's issues, expressed the State Department's resounding support for ratification, and Secretary Clinton publicly called for ratification of CEDAW, and Secretary Kerry has reiterated that that is a continued priority under the State Department for him. But, of course, CEDAW faces real obstacles to ratification. The human rights treaties that were last ratified by the U.S. were ratified during the Clinton administration: the Convention to End Racial Discrimination and the Convention on Civil and Political Rights. Even non-human rights treaties are very difficult to ratify currently. So, New START, the Arms Reduction Treaty, was ratified in 2010. But barely. It was a far, far heavier lift than anticipated, given that there was incredibly widespread and bipartisan support for the treaty. It was considered non-controversial in many ways, considered to be the easy treaty that the Obama administration would work on before turning to harder questions. And it was very difficult to get through, and only got through in the final days of the 112th Congress. So CEDAW faces the difficulty that any UN treaty, and particularly any UN human rights treaty, faces. There is a vocal and organized opposition which is very concerned about any threat to US sovereignty, to the notion of the US being bound by any international obligations at all, frankly, particularly if there's any sort of UN oversight of those obligations. Concerns about the possibility of enforcement of international human rights against the U.S., even in a non-binding context like the CEDAW Committee issuing observations about the United States' own behavior. But of course, there are also particular flashpoints for CEDAW because of its subject matter, and reproductive rights generally and abortion specifically is an important part of the domestic political conversation about CEDAW, and that has been an important part of the conversation about CEDAW for decades in the United States. So the Clinton administration sought to ratify CEDAW and did a real push, sent a treaty package to the Senate, which included a package of reservations, understandings, and declarations, RUDs, that the administration recommended be included as the Senate ratified CEDAW. They sent that package in 1994, and this was the last time that the administration sent a formal treaty package for CEDAW. So in some ways, they are the RUDs which remain on the table, not technically, but in how senators and this administration as well thinks about CEDAW these days. So among the RUDs that the Clinton administration proposed is an understanding regarding Article 12 of CEDAW. Article 12 is the provisions that Aaron spoke about eliminating discrimination against women in the field of healthcare in order to ensure access to healthcare services, including those related to family planning, and a further provision saying that state parties shall ensure to women appropriate services in connection with pregnancy, confinement, and the postnatal period, granting free services where necessary, as well as adequate nutrition during pregnancy and lactation. So the understanding that the Clinton administration proposed is that Article 12 permits states parties to determine which healthcare services are appropriate in connection with family planning, pregnancy, confinement, and the postnatal period, as well as when the provision of free services is necessary, and does not mandate the provision of particular services on a cost-free basis. The domestic abortion politics and policy, I think, is an important motivator for that understanding. It was meant to, I think, in part, not wholly, there are other theories and motivations for it too, but in part to be defensive against a claim that CEDAW would require the United States to pay for abortions for poor women. And when the Clinton administration proposed to the Senate that they ratify CEDAW with this REDS package, they testified that CEDAW is abortion neutral. They said nothing in the convention, and particularly nothing in Article 12, requires state parties to guarantee access to abortion. Whether or not abortion should be considered an appropriate service in connection with pregnancy is left to each state party in its discretion. And that, at the time, and actually for many years afterward, is very typical of how U.S. proponents of ratification would talk about the issue of abortion and reproductive rights in CEDAW, to emphasize that the word abortion doesn't appear in CEDAW, and to argue that CEDAW is abortion neutral, that you can ratify CEDAW without taking sides on an abortion fight one way or the other. The Clinton administration, in recommending this read to the Senate, said that if abortion is considered an appropriate service and is in fact provided, though, that Article 12 could be interpreted to require that abortion be provided without cost where necessary. Again, this was a motivator for the understanding, which was meant to say, we understand this to be abortion neutral, it doesn't require anything in relation to abortion. Don't be alarmed. But when the Senate Foreign Relations Committee considered the REDS package, they also considered a proposal put forward by Jesse Helms on the Senate Foreign Relations Committee around this issue as part of this conversation. And the Helms understanding was much more explicit and pointed, saying that nothing in this convention shall be construed to reflect or create any right to abortion, and in no case should abortion be promoted as a method of family planning. And that language, in no case should abortion be promoted as a method of family planning, doesn't just mean promotion of, say, substituting abortion for contraception, saying we don't need to give contraception, we'll just rely on abortion instead. In other federal law contexts, that language has been used to really reach most or all abortions, or at least all abortions other than those where the woman's life is at stake, or perhaps cases of rape and incest. So it's a very broad statement that says that the convention shouldn't be understood to reach abortion in any of these contexts. So in 1994, the Senate Foreign Relations Committee, on a bipartisan basis, recommended to the Senate that that the convention be ratified, but with both the Helms understanding and the understanding proposed by the Clinton administration that were meant to say that CEDAW has nothing to do with abortion. And then 2 months after the committee recommended this, there was an election, and the Republicans took over the Senate, and Jesse Helms became the chairman of the Senate Foreign Relations Committee, and that was the end of CEDAW in the Senate Foreign Relations Committee for a while. And Jesse Helms explicitly said that CEDAW is not going to move under me, and abortion is a reason, or one of the primary reasons why. In 2002, the Senate Foreign Relations Committee was chaired by Joe Biden and returned to the issue of CEDAW and once again considered the package that the Clinton administration had set up, and once again, on a bipartisan basis, recommended that the Senate ratify CEDAW with the Clinton administration read and with the Helms read. But the treaty didn't come to the floor for a vote in 2002 or any time since. So the Obama administration hasn't proposed any particular REDS package for CEDAW, and it isn't clear if it did how closely an Obama administration REDS package would track the previous package, whether there would be the same language or similar language about abortion in CEDAW. Some of the Clinton administration REDS that were proposed, for instance, one saying CEDAW doesn't require, that the United States reserves the right not to put women into combat are clearly no longer relevant because the United States has recently announced that they're going to allow women to serve in combat. So there are obviously things that happened in the Clinton administration that would require revisiting if the Obama administration were to propose a REDS package. Technically, the treaty right now remains before the Senate Foreign Relations Committee. The Senate Foreign Relations Committee could take it up if they wanted to. Technically, it has no reservations, understandings, or declarations associated with it at this point. Those REDS don't carry over to a new Congress. So there would be a series of new decisions to make about how or whether to treat abortion. And given that, frankly, Congress finds it hard to deal with any law that uses the word women without talking about abortion, there would definitely be an abortion conversation if and when the Senate Foreign Relations Committee returns to the topic of CEDAW. But the conversation will be at least somewhat different today because the CEDAW task force recognizes, and I think the administration recognizes today, that the claim that CEDAW is abortion neutral is not really accurate. CEDAW interpretation, implementation over the past couple decades has made clear that it's, I think, a real disservice to try to read abortion completely out of the treaty. Because the CEDAW committee has recognized that CEDAW, for example, is relevant if a country is imprisoning women for having an abortion, without exceptions for rape or incest, or if the woman's life is in danger. The CEDAW Committee has recognized that CEDAW prohibits countries from having rules that deny medical care to women who are suffering from botched abortions. That CEDAW is relevant to the question of making making sure that unsafe abortions aren't harming women. And that CEDAW is relevant to the question of maternal mortality arising out of unsafe abortions. And so, in the domestic political debate, I don't think that you will hear CEDAW proponents making that argument anymore. At least certainly, many of them will not be asserting that abortion needn't be part of the conversation because CEDAW doesn't have anything to do with abortion. But what you will hear is that it's important to focus on what specifically CEDAW has been understood to mean in the abortion context, because given how the CEDAW Committee has addressed abortion, what it has said when it has talked about abortion and reproductive rights, is focused on practices that are not only illegal in the US, but are actually widely condemned by those on both sides of the abortion debate. So very few anti-abortion advocates in the US argue that women should be imprisoned for abortion. That's not typically how the argument tends to go. Some people may think it, but they don't tend to say it. They especially don't tend to say that people who need abortions because they've been raped or because they've been victims of incest should be put in prison. Very few anti-abortion advocates in the United States argue that women should be refused medical treatment if they have an unlawful abortion. They don't argue that we should leave women to die in the streets if they've had an abortion that has been botched. So, abortion is a flashpoint and a motivator for the conservative base to oppose these treaties. It's even become an issue in discussions about the conventions on the rights of persons with disabilities, where there's a much stronger argument to be made that the convention is abortion neutral. But because abortion is an issue that will bring people to the phones, it becomes part of what you talk about when you talk about human rights treaties. It will become definitely part of what people talk about when they talk about CEDAW, no matter what happens going forward. But I think it's important that those who are advocating for CEDAW are now frankly acknowledging that there is a place for the reproductive rights conversation and the conversation about what CEDAW does, and what's important is to focus on how broadly accepted values, as well as laws in the United States, are also closely aligned with how CEDAW has been interpreted in this context. So that is what we are working on when we work on U.S. ratification initiatives.
Thank you very much. Thanks to your speech, we understand very well the long and very complex US ratification process. It's a world in itself, completely important. Now, let's talk with us. You can have some questions if you want, please.
And a microphone. Hi, first of all, thank you all so much for your very interesting and unique perspectives on CEDAW. So my name is Teresa Chan. I'm an MD-JD student at Berkeley Law and Mayo Clinic. And I'm working with AMFAR to develop a project in Thailand and Indonesia looking at how we can bring about legal health reform, stopping the practice of forced coercions and forced sterilizations in abortions of HIV-positive women. So this has been very enlightening today for me in particular. And so I was wondering, especially from all of you, getting your perspectives, in the intersectionality idea really struck me, especially since I'll be working and I am working with marginalized populations. And so have you seen in the recent years and recent decades, with the increased and growing numbers of multilateral organizations and committees and treaties, sort of siloing rights in general, have you seen sort of corresponding siloing of enforcement? I mean, for example, with women living with HIV, one of the issues we're struggling with is whether or not people would see this more as, an HIV discrimination case or, a general sexual and reproductive health rights issue. So I was wondering if you could speak to that a little bit, of whether or not siloing is a danger.
Thank you. Is there any question?
Hi, thank you. I would like to thank the speakers as well. My name is Samantha Koji. I'm from the Center for, I'm sorry, from CEDAW, Center for International Justice and International Law. I'm sorry, I get nervous when I have to speak in public. So I would like to ask if you have any particular insights comparing the petition system before CEDAW and before the regional protections of human rights. Because, I don't know, you mentioned cases that have been brought before the committee of the CEDAW, but do you think that there are particular cases that should be brought before the CEDAW, or they are better to be litigated before the regional system, such as the Inter-American System of Human Rights? So that will be my question. Thanks.
Hi, my name is Carmel. I just graduated from the LLM program at WCL, American University. My question is to Emily, particularly, not to scare off anti-abortionists in the room, but could you say something about best case scenario if they were to ratify CEDAW, what kind of proceedings or implications you could expect?
I think it's a moment for our speakers to begin to answer.
I'll start, and maybe we can just go down. In terms of your work in Thailand and Indonesia, intersectional discrimination, there has been some work on HIV-positive women. The Center, I believe, has done some work in Chile and in Namibia. There's a case. So there are some cases pending and some fact-finding with regard to that specific issue. But I think the broader question that we need to start asking ourselves, and this is really drawing from the criminalization literature, is why is it that we are criminalizing HIV-positive women? Why is it that, why are we criminalizing putting women who've had, say, stillbirths in jail? So there's a huge problem in reproductive health and sexual health with regard to the over-criminalization of women. Why are we choosing women to criminalize? Why aren't we going after those in financial fraud? I mean, there's a huge problem of under-criminalization in those areas, while there's a huge problem of over-criminalization in the area of sexual and reproductive health. And I think the idea of HIV-positive women is just a step in the series. I'll leave it to Avram to speak about the particular countries where fact-finding has been done and cases have been brought. In terms of the question on whether you should go at the international level with a case or at the regional level, you probably know about the Paraguay case. It's a land claims case where it was primarily a land claim case, but there was a subsidiary claim of a woman who died in childbirth because she didn't get access to maternity care. It wasn't developed, the decision, but at least there was, Paraguay was held responsible for the decision. I don't know what's happened with that particular decision, but that's an important case, came out before the Aline case. But I think the determination of whether to go regional or international is very fact-specific. It is also dependent on the kinds of objectives you have, what you want to achieve in the case. And I don't know what the litigation strategy was for example, with a lien, but I can guess that they might have thought that they could get a better decision, a more robust decision on equality because of General Recommendation 24, saying that when you neglect health care that women need, that's a form of discrimination. So that's probably why, it's a hunch as to why they went with CEDAW. Now that they have that holding, that very significant holding, a question I would have if I were sitting at the Center for Reproductive Rights is how can you build on that decision? And it might be, given certain circumstances in the Inter-American Commission or the court, that you could build on it. Depends on the judges, depends who's in there, depends on the facts of the particular case that you have at hand. So I don't think you can decide in the abstract whether you go regional or international. It's fact-specific, it's depending upon the country, it's depending upon the commission or the court, and what your particular objectives are.
Yeah, those are great answers to the questions. I'll just
not answers, they're just
so,
more questions.
No, more responses. So just a few thoughts. Yeah, I mean, I think in terms of the question that you asked about the forced sterilization, I mean, that's a huge issue. Yeah, the center, we published a publication about a year and a half or 2 years ago looking at the treatment of HIV positive women in the Chilean healthcare system, and included in the sort of series of violations, human rights violations that we found was forced sterilization. I worked also with International ICW, International Community of Women Living with HIV/AIDS, who had done work in Namibia and other places too, and sort of forced sterilization more broadly. And you also know, obviously, in Eastern Europe with the Roma and so on, that this is something that affects women with HIV, but also, disfavored minorities are sort of targeted. And then there's also that intersectionality of being a member of a disfavored minority and being a woman and being HIV positive as well. In terms of the question, I mean, I think you answered really well the question. I think it's a very sort of fact-specific, I mean, there are some cases, the U.S. is not a party to CEDAW, much less the optional protocol. So, if you're going to go to the U.S., you kind of, IACHR is the only show in town. But yeah, I think it really depends on kind of exactly what you're looking at. And the bodies change. I mean, the composition of IACHR changes, composition of the CEDAW. So I think it's all of those things. I mean, you want to, I think there's both the substantive right, there's what the remedy is, and, to be frank, there's sometimes a little bit of forum shopping, for lack of a better term, where you think at that moment this is going to be a more receptive, and maybe right now CEDAW is a better place for A, B, and C kinds of claims, and IACHR or some other regional body is a better case, a better forum for other kinds of ones. And I'll leave the ratification one to you. I mean, I'll just say, I think a challenge, for those of us who are proponents of CEDAW ratification is sort of how you walk this line of being accurate, but also not kind of scaring away people unnecessarily. And I think, if you come in and you say, CEDAW, it's going to change everything, no law will be everything will be subject to scrutiny, that makes CEDAW sound really, really important. It also makes it sound really scary for a lot of people. If you go in on the other hand, as some of them, and say, this changes nothing, every U.S. law is in compliance, and if it isn't, it doesn't matter, because we're the U.S., we're automatically, then the answer is, well, then why do we need the treaty? If it isn't going to do anything, what's the point? And that's sort of the alternative, and people try to square the circle and explain, that U.S. leadership on this is really important for other countries where compliance is much worse, because fairly speaking, even though U.S. might not be in complete compliance of every provision of CEDAW, generally, legal status of women in the United States is very good compared to many parts of the world, not all, but many. But I'll take it to you in the sort of full.
Rebecca want to add something.
Who's doing the forced sterilizations in Indonesia and in Thailand? Is it the doctors?
Oh, yes. Okay. So it's coercion, it's sexual coercion essentially. And so there's a lot of human rights violations wrapped up in this one single act. For example, feeding of misinformation, or violation of privacy. And so it's just, for me, it was just figuring out whether or not having, for example, CAT recently recognized that forced abortions is a form of torture and invasion of privacy and whatnot, whether or not that strengthens sexual and reproductive, the recognition of sexual and reproductive rights, or if it almost detracts in a way because then it's another committee trying to figure out where, it's sort of a turf war where, how much of this right can they claim and try to enforce without bringing in the other things,
So I asked the question about who's doing these sterilizations of HIV-positive women because Christina Zampas, who's a former, used to run the European and brought these cases around Roma sterilization, she has worked with the Ethics Committee of the International Federation of Gynecology and Obstetrics and has a policy. But the problem you're up against is you can't really solve the problem by going in there and raising hell and saying it's all the doctor's fault because you want them on side. So one question is, how can you get them on side by maybe using the norms of the FEGO Ethics Committee and beginning to work with some of the medical associations in these countries? Obviously there's a group of doctors who are doing this who probably for very benevolent reasons. They think they're doing the right thing. Although, obviously reasonable people can differ on that issue. So how can you start a program of sensitizing doctors to the fact that they are committing human rights violations without pointing the finger at them, for them to begin to raise their consciousness, for them to come around. So I'm very sensitive to this because I did a book, Reproductive Health and Human Rights, with Dr. Mahmoud Fatala, who used to be the president of FEGO. And he kept saying, you cannot point to the doctor as, you can't go after them in terms of medical malpractice. This is not. So we developed a series of case studies, and in that book there's a case study on sterilization. So a parallel track is how you begin to introduce this in medical education and begin to sensitize doctors. So that's one approach. Now the other, another thing that occurs to me is on the Roma sterilizations in Czechoslovakia, Romania, Hungary. They have what's called flooded the forums. Literally, the Center for Roma Rights, is that right? The Center for Reproductive Rights, the Center for Roma Rights, there's been a whole effort to flood the forums around this problem. They've used the European court, they've used domestic courts, and finally, this issue has, am I right, Avram? I'm looking at you, it's finally written a critical mass. And so, you not only need buy-ins from the medical community in these countries, you need buy-ins from the judges, you need a strategy that floods different forums. Yes, the judiciary, yes, maybe there's some national human rights commissions, but I think if they had only brought one case, albeit important, they wouldn't have reached the critical mass to raise this issue about Roma sterilizations in Eastern Europe as egregious. And maybe if this is pervasive, you might want to start with the inquiry procedure under CEDAW. Both those, I don't know if they ratified the optional protocol to CEDAW. Well, then you might, if it's really an egregious problem of coercive sterilization of HIV positive women, you might want to request an inquiry procedure for CEDAW. It's certainly grave, and if it's systematic, I mean, it's grave or systematic, so there you go.
So I mean,
So on the question of what U.S. ratification of CEDAW would mean, I think it is the case, and certainly Melanie Rivera testified and spoken about this, Secretary Clinton spoke about this, they reiterated that it is meaningful that the United States is not, has not ratified CEDAW in our international engagement, that when we seek to persuade other countries to live up to their obligations, their human rights obligations regarding women and girls, that it is a common response that what do you have to say? You haven't even ratified CEDAW. And that when advocates in countries like Afghanistan seek to hold their countries to the obligations that they've undertaken in ratifying CEDAW, it's a common response that that the U.S. hasn't even ratified CEDAW. How can you say that women's rights are universal human rights? So I think that it does have a significant meaning for how we can engage as a moral leader in the world. And it is an important reason to ratify. Now, it's the case that when the U.S. ratifies human rights treaties, we attach a non-self-executing rule to them, which in essence means that nobody gets to go to court to say, you violated my rights under CEDAW, which limits the amount of direct change that CEDAW can affect in the U.S. I do think, again, however, that there's a value in undertaking the self-evaluation and self-analysis and engagement that CEDAW requires of ratifying parties to systematically take stock of the status of women in the United States on these various measures in a way that the federal government doesn't in any systematic way at this point, and to engage in the conversation with the CEDAW Committee about where we are doing well and where we could do better. But that also matters, so it's a soft effect rather than a hard effect. And finally, I think that even given the non-self-executing rule that you can assume would be applied if CEDAW were ratified, that nevertheless, even if someone can't go directly to court to enforce it, that the fact that we have ratified CEDAW makes a difference to at least some courts who will be trying to figure out what our obligations are under our own Constitution, how we should interpret laws where there is an ambiguity to be consistent with our ratification of CEDAW. And it's a softer effect. You can't say if X then Y, but I think, again, that it matters in the long scope of things to establish these principles as core principles that this country has formally embraced and endorsed. But Aram is absolutely right that as advocates, it is a difficult dance to say it's incredibly important, but don't worry, nothing bad will happen, nothing will change us. And it's also very difficult because State Department's policy is that it will only seek ratification of treaties that it judges us already to be in compliance with, or unless there's a specific rule that would be attached saying, well, don't worry, we don't have to comply with this particular part that we're not in compliance with. So just as far as working with the Obama administration to try to get them to support the treaty vigorously, their necessary prerequisite is a statement that, don't worry, it doesn't change anything, we're already fully in compliance, and to the extent we aren't, we're going to scratch out that part of the treaty. So it's an advocacy challenge, to be sure.
okay, is there any other question? It's time. Okay.
I guess I'm curious what the stock-taking exercise looks like in the United States, given that a lot of the action in sexual health and reproductive rights seems to happen at the state level. And what do you envision at the National Women's Law Center, that exercise looking like? And I'd be curious, after we hear from you, if Professor Cook or Aaron, if you have any observations from watching other states with subnational components trying to walk this line.
Yeah, that's a good question. I mean, there is some experience with how we do this sort of thing. The U.S. has ratified CERT, for example, and has submitted a couple reports under CERT. The U.S.'s reports do tend to focus more on the federal government, though including federal government enforcement actions against states that they have been discriminating basis of race, for example. So to the extent the Department of Justice is bringing racial discrimination claims against state police departments, that sort of thing is the sort of thing that the U.S. will discuss and reflect in its reports. But also there's an important shadow reporting process, obviously, where part of the value of this engagement, and it's not just the self-reflection of the federal government, which I think is important in and of itself, but also in that it's a forum for NGOs and others to also engage and say, here's a fuller story. And that engagement has typically not limited itself to here's what the federal government has formally done as the federal government, but it's taken a much broader interpretation and taken a broader view of how human rights treaties are appropriately considered and enforced. So I think ideally, yes, that self-reporting, self-analysis process wouldn't be limited to the federal government narrowly. I think so far the federal government tends to report on what the federal government does. But you guys have any thoughts?
Yeah, it always strikes me as sort of amazing that, you know, the same people who are you know, willing to sort of tell the world to sort of stick it when it goes to, you know, interventions in other countries, or, you know, flouting international law in other ways when it suits the U.S. interest, are sort of terrified of this non-binding committee of experts who might recommend, you know, that I don't know, you know,
Public education.
right, you know, some kind of public education campaign, you know, we're going to flee for the hills, and as if, you know, CEDAW is going to come in with their black helicopters, and it's just sort of absurd, and it's really very much ado about nothing. I mean, we don't have to speculate what this looks like because the U.S., as Emily said, is already a state party to a number of these, right? I mean, literally tomorrow, I'm going to a meeting where there'll be members of the U.S. government meeting with civil society, and civil society will talk about some of the issues that will arise when the U.S. is reviewed by the Human Rights Committee, which is the treaty body that oversees the International Covenant on Civil and Political Rights, which the U.S. is a state party to. And one of the issues that I will be mentioning is the proliferation of state laws against abortion, which is one of the issues. I mean, you know, as a nominal matter of international law, as I'm sure everyone knows, I mean, the federal state distinction is of no moment. Now, obviously, that's not how it actually plays out in the U.S., where you have, you know, I forget the Medellin case, where you have George W. Bush asking, you know, Texas to uphold an ICJ preliminary measures decision, and the state of Texas was a very, right, so we know that doesn't actually play out, but the reality is that it ought not matter, and certainly from a sort of legal obligation that stems from the U.S. as a sovereign to the treaty body and to the community, you know, the state-federal distinction doesn't matter. But, you know, by and large, these are, you know, recommendations. They are not formally binding, and there's not even a way that you can go to court directly because these treaties are not self-executing. The Superintendent reaffirmed that recently. So, yeah, it's sort of unclear what the U.S. is afraid of. And the fact is, you know, the U.S. participates in other parts of international machinery and you know, submits a list of issues and then goes through and engages, and that's what's happening right now. You know, with the Human Rights Committee, the U.S. report is quite lengthy and you know, fairly fulsome. And you know, the Human Rights Committee engages the U.S. or the U.S. engaged through the UPR, the Universal Periodic Review process, and gets asked tough questions about you know, sensitive issues about you know, torture or enhanced interrogation, about you know, detention and Guantanamo. I mean, all these things that are also fairly sensitive issues, and he just gets asked about them, and it has a response or it doesn't, and you know, the world doesn't collapse. So it's really unclear why this in particular is sort of causing so much you know, consternation.
We have 5 more minutes, so if there is last question.
So I'm not very experienced in this area of the law, so this might come off as kind of a layperson's question. But do you think that these arguments ever potentially run the risk of being evaluated as somewhat discriminatory themselves, and that they don't focus on, well, they might, I don't know, but that they're not broader in focusing on the general denial of health rights and immediate medical care to individuals as a whole, And has there been any effort to sort of maybe broaden that to bring out a larger contingent of people in support?
Well, I just want to go back to your question about the federal provincial. In Canada, it really depends upon your leadership. We had a very, very good system under previous prime ministers about federal provincial consultation with compliance with CEDAW, and it was very serious. And I think that's fallen by the wayside. So that's a formal matter. But I also want to emphasize the importance of the informal routes. The Center for Reproductive Rights has consistently filed a report on the discrepancies in maternal mortality with regard to, is it with the Race Committee? I'm looking at you. Do you know, maybe this is part of the Senate?
Yeah.
I cited it in one article, and it was incredibly important because for different groups dealing with indigenous, dealing with Latino Americans, dealing with Afro-Americans, just to document the discrepancies in maternal mortality in this country has been very important, and to use it as a forum. I cite those reports. They do it consistently, I think before the Race Committee when the U.S. is up. So the importance of shadow reports, particularly where you're not going to get leadership from the government on certain issues, is incredibly important. Unfortunately, in Canada, we do not have a very strong civil society, so we don't have that report. I don't know how it is in France, but it's terribly important to use the informal part of these treaties to at least document some of the wrongs that whether you can sue or get remedies is another question, but the documentation process is very important. I point to, I think there was a CEDAW declaration in the city of Sao Paulo, Brazil. And so there are several, and I think Los Angeles has had such a, San Francisco. So I think there's ways that civil societies can push these issues in ways that are very, very creative that might make a difference for the city, with particular subgroups of women in Sao Paulo or subgroups of women in San Francisco. So the fact that they're the formal bureaucratic governmental mechanisms might not be polished the way they used to be in Canada, and it was a very, very important forum for NGOs to come together. I think in some countries those forums are being used just by mere fact that they've signed or ratified. So there was another question about going from reproductive rights to the right to health care more generally. Well, I'm all for it, but if you can't get to the moon, let's at least get to around the block. The debate in this country on the Affordable Care Act is you can't get it all, and the problem is in some countries. For example, in Canada, our healthcare system is being eroded by the private sector, particularly under the current government. So where do you begin to draw the line? And you draw the line on a case-by-case basis. You draw the line in British Columbia right now, where colleagues are trying to support our healthcare system. You draw the line in different ways, and if you try to go for broke, you're often not going to get there. So I'm an incrementalist by nature. You can't be in women's rights and go for broke because you'll never get it. But I think the incremental approach is a very important approach because you begin to educate people along the way about what is required in terms of affordable care. I'm thinking about a group of Vanderbilt medical students in the 1980s who started a clinic in East Tennessee where people were dying of black lung. And the guy who started that is now the #2 or #3 in Health and Human Services in looking at affordable care, overseeing affordable care. Well, he started out with a conviction and a passion that we need to do something about community health in East Tennessee. And had he not had that experience, he probably would have ended up, I don't know, some corporate law firm. So, and unfortunately that community health center is now gone by the wayside because we are not educating in medical schools enough about community health and preventive health. But it's incremental. You have to use each experience. So that's, I'm all for going to broke, and I always sort of try to relate women's health to larger issues, like women's access to maternity care is part and parcel of access to essential health care.
Just a question, of sort of the question that was underlying it. Was the question more, does the focus on sexual and reproductive health sort of somehow detract from the larger goal of women's health, or does the goal of women's health take sort of detract from the larger goal of health as a human right for men and women?
I mean, a little bit of both, but it just seems like there have been some challenges moving forward and getting a lot of support. So does just broadening the scope generally get a larger contingent of people so that you can push forward what you're looking for with some other ideas kind of tagged on the side?
Yeah, I mean, I think that's right. There's always a tension, I think, between looking at women. I mean, someone asked about, you asked about the sort of siloing question, and sort of, are there human rights versus women's rights? And obviously, women are humans, and so you think, well, why do you need women's rights, right? I mean, human rights apply to everyone. Well, I mean, and in some ways, I think that's actually right. I think that the job of women's rights, in some ways, is to put itself out of a job. So that when we think of human rights, we think collectively of everyone. But historically, that hasn't been the case. I mean, both in domestic law and international law, historically, predominantly, if not solely, men were rights holders and rights bearers, and women were the sort of acted upon. And I think it's actually important that CEDAW doesn't sort of create two separate sets of measures, one for women and one for men, where there's a competition. And specifically, I mean, Article 12, for example, says, states parties shall take appropriate measures to eliminate discrimination against women in the field of healthcare in order to ensure, this is the important part, on a basis of equality of men and women, access to healthcare services, including those related to family planning. The trouble is, obviously, if you're talking about access to liver transplants or appendectomies, men and women are similarly situated, generally speaking. But when you're talking about reproductive health care, what is parity? And there isn't a direct correlation. And so that's, I think, where I think that question sort of comes from. But the goal of Article 12, and really CEDAW as a whole, is not to sort of catapult women above men. I think it would be problematic if that were the case. There's obviously exceptions for special measures, but leaving that aside, it's to create and promote equality and non-discrimination, and really everything is predicated on a basis of equality of men and women, and I think that's what we're all sort of striving for.
I think it's time to close the event. I would thank one more time. They worked